Okay, now we'll discuss the defense of property defense. One can defend property from theft, damage, or destruction, or in the case of real property, from damage or trespass. Now remember, personal property is movable property, and you can defend your movable property from theft, damage, or destruction, and you can also defend your real property, that's land and anything attached like buildings. You can defend real property from its being damaged or from trespass, because obviously no one's going to pick up your house and steal it. That's movable personal property. But you can defend both. The threat must be imminent, occurring or about to occur. However, if the property was taken in the past, force cannot be used to reclaim it. Instead, the owner must go to court. Also, only reasonable force can be used to defend property, and deadly force is never permitted in the defense of property alone. And generally, before using force to defend against a trespasser, you have to ask that person to leave. Now, sometimes you'll be defending property, and remember, you cannot use deadly force to defend property, but the situation evolves into the person attacking you, and then the defense shifts to self-defense. So if you're defending your property and the individual who's trying to take or destroy it or damage it suddenly begins to attack you, it's no longer a defense of property situation. It's now a self-defense situation, and depending upon the level of force being used against you, you can use non-deadly or deadly force, based on the complete rules of their usage. Keep in mind also that one can use more force to defend one's home, and in some states one business or even an occupied vehicle, under something called the castle doctrine. This allows the use of force to defend one's home, including the use of deadly force, when an intruder is entering or in the home and the occupant believes the intruder is going to commit a crime of violence against the occupant. And there's no duty to retreat before using deadly force in your home under the castle doctrine. So in the way of a brief recap, you can defend your personal property against people stealing it, damaging it, or trying to destroy it, or your real property, your land and home, against damage and trespass. But as a general rule, only non-deadly force. We value life over property, so we don't let people use deadly force to defend somebody stealing a handbag. And in addition, you can use force more easily and more safely, legally, and not have to retreat when you are in your home, your castle. The rules are a little bit different from that, and you can use deadly force when you think the person who's intruded on your home, or in some states your business or vehicle, is going to commit a violent crime against you or another occupant. And in any situation, whenever you're in your home, and if you're justified in using deadly force, under the castle doctrine, you don't have to retreat. Again, these rules are pretty complicated. Personally, if I'm being threatened in my home by somebody who I think is going to kill me, I'm going to try to get out of the home and call the police, because they're the ones who get paid to put their life on the line and protect the citizens. Okay, now we're going to talk about the necessity defense, also called the choice of evils defense. The necessity defense protects a defendant from a criminal liability when the criminal act that defendant performed was committed to avoid a greater evil or greater harm. Now, the necessity defense requires three elements. First, the defendant has to be faced with an imminent harm to himself or herself or somebody else that is beyond the defendant's control. And the harm that the defendant caused by committing the criminal act has to be less harmful than the harm that was threatened. And because murder is the ultimate harm, many jurisdictions do not allow the necessity defense to be used against an act that causes the loss of a human life. And finally, the defendant must have an objectively reasonable belief that the harm sought to be avoided by this criminal act is imminent and can only be avoided by committing a less harmful act. So again, necessity, bottom line, you commit an illegal act. That's bad. But you only do it because you have to do it to avoid a more harmful act. Let me give you an example. In fact, I was in a position to use the necessity defense before I was even a police officer. I was in the New York State National Guard, and I was in the motor pool, and we were on our way up to a weekend military drill in upstate New York. And I and my compatriot Sal, he was also in the motor pool, we were driving the wrecker. It was a big tow truck that tows other trucks, 5-ton wrecker. And I was kind of dozing off in the passenger seat, and Sal took a wrong turn. And I suddenly wake up, and we are driving down a desolate country road. Instead of being on the thruway going up to Camp Smith, we're on this desolate country road. So I say, Sal, where are we? And Sal says, I don't know. I said, we obviously took a wrong turn, so let's go back the way we came. So Sal begins to make a U-turn across this 2-lane, 1 lane in each direction road. And as he's backing up for the second part of this U-turn, we hear rumble, 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 and the drive shaft of the truck splits in half and falls on the ground. So now our massive tow truck, and this tow truck is like 25 feet long, right? Because it tows other trucks. It is now totally blocking both lanes of traffic. And to make matters worse, this is camouflage. This is a military truck, and this is back in the early 70s, so it's that dark green camouflage. And we don't have any big lights on the truck because against a military truck. And amazingly, even though we are in a signal battalion, we don't have a radio. So now we have our camouflage massive truck blocking both lanes of traffic on a country road with no lights. So we're sitting there, and I suddenly see in the distance a tiny light, which I don't really pay much attention to. But when I look back a minute later, the tiny light is larger. So now we realize there is a car speeding down the road towards us. And we didn't think this car was going to see our camouflage truck. So we get out of the wrecker and we're running down the road towards the car. And we're also in camouflage, right? Trying to wave the car to stop, but the car doesn't see us. And the car slams in at full speed into this massive tow truck, causing virtually no damage to the tow truck, but collapsing the entire front engine compartment of the car and injuring the driver. So the driver is unconscious and he's bleeding. The car is all crashed. There's the smell of gasoline. Sal goes to run to get flares, which I said, don't get flares. There's gasoline all over the place. So I look around and I see on top of the hill a building, a closed building. And I race up the hill, and as it turns out, it's the office of a surveyor, but it's closed because this is like 9, 10 o'clock at night. But through the window on the desk, right on the other side of the window, I see a telephone. But the door in the window is locked. So I picked up a rock and I broke the window glass. I reached in, I pulled the phone outside the window, and I dialed 911 to get police and ambulance to the scene, because this person was bleeding to death. And the ambulance came, they took him to the hospital, and he lived and everything. But here's the point. I broke the law. When I broke that window, I committed the crime called criminal damage, criminal mischief, intentionally damaging the property of another. But the police didn't arrest me, or even if they had, I never would have been convicted in a court of law, because this is a clear case where the necessity defense negated my criminal liability for damaging the window. I was in a situation where somebody else was faced with imminent harm. The guy was going to bleed to death, and this was beyond my control. And the harm that I committed, breaking a glass window, was far less harmful than the alternative, to not be able to call for help and maybe having this person bleed to death. And an objectively reasonable person would have believed that the harm sought to be avoided, this guy bleeding to death, was imminent, and that there was no other way that I could have corrected his death. I didn't have a surgical ward with me. So this is an example of a necessity defense. I chose the lesser of two evils, breaking the window and damaging it, as opposed to letting somebody bleed to death. And I was therefore not guilty of damaging the window, the necessity defense. Okay, now we're going to talk about the duress defense. The duress defense asserts that the defendant committed an illegal act because he or she was coerced into doing it by the use or threatened imminent use of unlawful force against himself or herself or somebody else. And generally, the criminal act committed under duress has to be less serious than the harm threatened or used. So consequently, duress is generally not a defense against liability for intentionally killing somebody else. And as with many of these defenses, the defendant is going to be held to an objectively reasonable standard. In other words, it's not what the defendant believed, but would a reasonable person in the same situation have believed that it was necessary to commit this other illegal act based upon the use of force against yourself or somebody else. Let me give you an example. Classical example of a duress defense. You are a bank manager. The bank closes, you come home. You open the door and you discover your wife and two children are tied up on the floor of the living room, and there is a guy holding a shotgun pointed at them, and he says to you, here's a duffel bag. Go back to the bank, open it up, go in the vault, fill this bag with money, bring it back to me. If you don't do that, I will kill your family. You go back to the bank, you're the manager, you have a key, you go in, you get into the vault, you put the money in a duffel bag, and you go back to your house and you give it to this guy. Now, you've committed larceny. You took money from the bank. It wasn't your money, so you stole a lot of money. That's a crime. However, in this case, when the authorities find out, you would claim the defense of duress. You would state that you committed this act because this guy was threatening to kill your family. And the death of your family would be a far more serious harm than your stealing the money. So consequently, you should not be found guilty of stealing the money. And again, this is an objectively reasonable standard. Doesn't make any difference how firmly you held the belief that you had to do this to save your family from a greater harm. It's would objectively reasonable people with the same facts have concluded that this was okay to do, that what you chose was the lesser of the harms and it was unavoidable. That is the duress defense. And by the way, as an afterthought to the duress defense, in addition to being charged with kidnapping and coercion, reckless endangerment, this guy holding the shotgun would also be guilty of the bank robbery. In duress cases, the coercer would be subject to criminal liability for the criminal acts committed by the coerced, you the manager, under the concept of criminal liability for the conduct of another. Now, this is in a different part of the penal code, but it's an interesting concept. Here in Arizona, and it also applies in most states, a person is criminally liable for the conduct of another if the person is made accountable for such conduct by the statute defining the offense, or acting with the culpable mental state sufficient for the commission of the offense, this person causes another person, whether or not such person is capable of forming the mens rea, to engage in such conduct. And in the situation we're talking about, the guy with the shotgun caused the bank manager to rob the bank. So under the criminal liability for the conduct of another section, he's guilty of the bank robbery also. So that's another thing to keep in mind in terms of duress and liability. The final defense in this lesson is the consent defense, and it'll only be discussed here in terms of non-sexual acts. When people consent to have criminal acts performed upon themselves or their property, then that consent generally eliminates criminal liability for the actor. However, the consent to this criminal act being performed upon a person must be voluntary, and consent made under threat of negative consequences is not voluntary. Involuntariness could result from the threat of force, the threat of exposing an embarrassing secret, or doing anything that might injure or harm the victim or cause others negative consequences to them or other people. So if you get somebody to consent to allowing you to do something to them, injuring them, what have you, it has to be voluntary. No threats of force, no threats of doing bad things against them, exposing secrets to themselves or third parties who you may care about. In addition to being voluntary, the consent to having an illegal act performed upon you, and therefore no liability to the person doing it, the consent must be knowing. And knowing consent cannot be made by people who are underage, mentally incompetent, intoxicated, deceived, or under duress. So a child could not consent to you performing some illegal act on them. Somebody who's mentally incompetent, very low IQ, insane, somebody intoxicated severely. If you deceive somebody, that is not consent. Or if you use duress, you threaten force upon them. That is also not knowing. And anytime consent is either involuntary or unknowing, it is not legal consent, and the person who performed the criminal act on the other person would basically be guilty of that criminal act. They could not claim the consent defense. In addition, people cannot consent to being killed or seriously injured, although causing injury or death during government-licensed boxing or dangerous sporting events would trigger the consent defense. If it's a state-licensed boxing match, each person is trying to cause injury to the other. And while that ordinarily would be assault, because they both have mutually consented and it's a sanctioned match, there would be no assault charges if one person injured the other. Mutually voluntarily fighting in a fight club scenario, like in the movie, where they're being paid to fight each other or they're agreeing to fight each other, but it's not officially sanctioned, may or may not be covered by the consent defense against causing serious injury or death to your opponent. That's probably a state-by-state situation. When medical practitioners injure people while practicing accepted medical procedures on them, that is also covered by the consent defense, or in some states, a separate legal defense for medical personnel. I mean, if a doctor is doing surgery on you and he opens up your stomach with a scalpel, he's causing physical injury to you, and that would normally be assault. But you've consented to this procedure, so he would not be guilty. The doctor, he or she would not be guilty of assault. And that's the consent defense.